which is obviously much better now. But it is. It's much bigger. It's got more to it. London's great. Yeah. I mean, historically, it has a good job of like maintaining conditions and all that. But they've gotten much better over the last few years. And, no, north. It's another, from where you can it's another 45 minutes. But considering it's only a couple hours, why not do it? Yeah, so that's Sugar Bush is another issue. Yeah, it's a little less traffic. They move people around. With high-speed lift, Sugar Bush is further. It's not my strong suit, but I think Bloomington's sort of here and then Sugar Bush is further north and this way. You'll look at the map and be like, I don't know what game is out here. So don't hold me. Oh yeah. And after learning on it's fun. Oh my God. It's two different sports. When you're learning on board too, you're like hard, you're ready for anything from one month away. It gets so cold and icy. Yeah. Board is great conditions, but that's like one day a year. But it's got great terrain. Yes, we do.
So we're back on the record, and we're going to move along to the topic of the indemnification clause. We'll start with the Seneca Lake communities.
Thank you, Your Honor. The Seneca Lake communities have raised a substantive and significant issue regarding the adequacy of the indemnification provision contained in the draft permit conditions to effectively mitigate significant adverse environmental impacts from the proposed project. The issue is substantive because, as I will address, there is sufficient doubt about the applicant's ability to meet statutory or regulatory criteria applicable to the project, such that a reasonable person would require further inquiry. And it is significant because, again, as I will address, it has the potential to result in the denial of a permit, a major modification to the proposed project, or the imposition of significant permit conditions in addition to those proposed in the draft permit. The indemnification provision contained in the draft permit conditions, which is condition number 9, is either unreasonably ambiguous and or inadequate to mitigate potential significant adverse impacts from the project. Condition 9 requires the applicant to, quote, accept the full legal responsibility for all damages, direct or indirect, of whatever nature and by whomever suffered, arising out of the storage facility's construction and operation to the extent such liability is attributable to the action of the permittee, its employees, agents, contractors, or subcontractors, and to the extent the permittee is liable under the law for such actions. The permittee must indemnify and save harmless the state from suits, actions, damages, and costs of every nature and description arising from such actions. And Your Honor, I would pause, and I forgot to carve out time for rebuttal and request 4 minutes, please.
Sure.
Thank you. This provision...
Just a minute.
Okay.
I've got to do my own bailiff here, so...
Okay, so this provision is ambiguous in that it appears to be limited to that liability which is already established pursuant to applicable law. Again, The final clause of the first sentence of the provision uses the conjunctive and says, and to the extent the permittee is liable under the law for such actions.
Can I ask you a question real quick?
Sure.
So can you identify which regulatory provision of the ECL is at play in this? Which regulatory standard is not being met by this indemnification clause?
Well, we would argue that generally speaking, the gas storage law requires that I don't have it in front of me, but requires permit conditions sufficient to protect against adverse impacts. And
Right.
again,
and that would include then an indemnification clause by the permit holder vis-a-vis the public?
to the extent that well, I'll get to that, but to the extent that an indemnification provision is being proposed as mitigation, potential mitigation for significant adverse impacts, and this is also an issue under SECRA, and that would be the other provision we would cite, then yes, that needs to extend to the public and to any entity that
There are places in the environmental conservation law where there's express authority for the department to impose payment of a bond or something like that. Are you aware of any provisions like that under Article 23 of the ECL?
I'm not aware of any provisions like that under Article 23 of the ECL. I haven't looked to see if there are any provisions like that under Article 23, but I'm inferring from your tone that there are not any. I'm happy to take a look,
I'm
though.
not aware of them.
Okay.
And maybe others will.
And I'm happy to take a look, but I don't think the absence of such a provision means that in the sense of the need to satisfy the requirements not to harm the environment, whether under SECRA or Article 23 of the ECL, that the imposition of an appropriate financial surety requirement of some kind or another is required.
All right, so if the department has the authority to impose such a surety requirement absent express statutory authority, would that be your view? Assuming there is no such statutory authority.
That would be our view, yes, Your Honor. Should I continue? So again, we argue that the provision is ambiguous, even to the extent it extends only to coverage of the state, in that it is limited by the clause and to the extent the permittee is liable under the law for such actions. In that sense, it's merely a truism and repeats that which the law would otherwise hold. In addition, the provision appears to be limited in that the second sentence suggests that its applicability is limited to the state, presumably on the basis that the state would have permitted a facility with the potential for an accident or other event that could impose actual or substantive costs for which the state does not wish to be exposed to liability. To the extent the second sentence, in fact, so limits the first, it renders the condition, oh boy, inadequate to protect potentially impacted entities, including the Seneca Lake communities in the event of a severe incident. I don't want to cut into my time for rebuttal, but I would have gone on to point to the testimony and offer of proof that is contained in the affidavits of Mr. Kuprowitz, Mr. Horn, and Mr. Bromka the latter two on behalf of the City of Geneva and Village of Waterloo, both of which operate water treatment facilities that serve collectively thousands of citizens around Seneca Lake.
I saw your brief, and you have 4 minutes with reservation. So.
Thank you, Your Honor.
The Finger Lake Wine Business Coalition?
Thank you, Your Honor. I'd like to reserve additional 4 minutes in rebuttal. Yes, Your Honor. The Finger Lakes Wine Businesses Coalition would also like to petition for amicus status on this particular issue. We feel that we have a unique perspective on both the law and the policy concerning the indemnification provision that would be of value to the court in examining this issue. You asked a moment ago as to the regulatory authority for even examining the indemnification provisions. And what I would say to you, Your Honor, is that as determined by Bath Petroleum Storage Inc. At 309 F sub 357 375, which was a Northern District of New York decision that's cited in our brief, ECL 23-0301 is clear that the regulation of LPG's underground storage is to protect landowners' rights and the general public. And they cite ECL 23-0301 for that provision. We would submit that that same provision brings into play here the indemnification that has been put in the draft permit.
Well, the indemnification appears to me to be, I mean, some people had analogize a permit to being essentially like a contract between the state and an applicant or a permittee, and that's sort of the typical indemnification clauses between the state and the applicant about whether or not holding the state harmless for the actions of the applicant under pursuant to the permit. But insofar as imposing upon the applicant a requirement to have a bond or some sort of surety for harms that might be caused vis-a-vis the general public, there's no specific, do you have any other more specific provision in the ECL that would apply? You're generally relying on the general proposition that the department is supposed to protect human health and the environment in reviewing a permit under Article 23.
I would agree that there is not a specific provision in Article 23 that speaks to that, but I do think that the department and in fact the state has the authority to protect the public health.
But, okay, right, but would that also extend, I mean, again, there are provisions in ECL that actually give the department the express authority to impose bonding, sureties and whatnot. Doesn't that suggest then the absence of that under Article 23 suggests the legislature did not intend for the department to have that power?
And we're not necessarily proposing that there be a bond in this instance, Your Honor. What we are proposing, and that we think that should be examined in the context of an adjudicatory hearing, is that the applicant's ability to cover the kind of catastrophic loss that could occur here should be examined before issuance of the permit. That if, in fact, we were to say that the corporate entity is incapable of dealing with the support services that would be necessary, the kind of damages that could occur specifically for my client, it could have a devastating impact on the businesses in the region, that this entity needs to be examined carefully to determine whether or not they have the financial resources to address any of those concerns. And although I understand there's no bonding, and we're not asking for a bonding element to be imposed because we submit that that's not set forth in the statute, we do think that it's appropriate in determining whether or not to issue this draft permit to determine that the applicant can in fact address those very serious concerns that are somewhat unique given the catastrophic injury that could result. In the Krubowitz affidavit, he submits that there could be millions, if not billions of dollars in damages in the event of a catastrophic incident. And he relies upon his experience in the industry and the type of accidents that have occurred historically to support the concept that this is an important issue to resolve prior to issuance of the permit.
Do you cite to me any authority under SECRA or the ECL where it indicates that among the things we should consider is the fitness, I guess, of a business entity to be able to live up to its financial, liabilities in the event there is some sort of catastrophe?
I think the entire premise of SECR, in terms of looking at the mitigation of environmental impacts and establishing that, in fact, those impacts can be mitigated or can be addressed throughout the SECR process, I don't think they preclude consideration of those issues.
I was asking if whether or not you're aware if there's any, if we've ever done that.
I'm not, Your Honor. I'd certainly be willing to look at that issue and would like an opportunity to address it in a post-issues brief.
Absolutely.
Because I do think that it's a very important and unique issue. I think historically this type of a situation hasn't been examined in that context. I don't think that precludes us from examining it in this context here. And I think that my clients, as an amicus, would like an opportunity to bring to the court the very policy issues that are presented by this type of a determination. That the fact that it has not been done historically, and even as this industry develops, does not mean it should not be done in this instance. It does give us an opportunity to go forward looking at what has happened around the country and with these types of facilities, the types of damages that have been incurred, and the opportunity to resolve those situations. Here we could do it in advance, in effect mitigate the potential economic catastrophe that could result as a consequence of these types of actions.
All right, thank you. We'll have 4 minutes.
Thank you.
Thank you again, Your Honor. In my presentation, I am going to address two components of the arguments that you've heard today. I'm going to address the seeker aspect of the arguments, and then I'm going to address the ECL/statutory regulatory components. I'll first address the seeker component. Ms. Tour said something that was notable in regard to the scope of seeker. She said and ended, we are suggesting this issue to mitigate the economic impacts. That's what she said. And we put in our brief, and the precedent is resoundingly clear, that economic issues are not within the scope of seeker. The law has been clear on that since seeker was created in 1978, and I'm aware of no decision that even undercuts that in the least. With regard to the issue that the communities raised in their argument, they said it would mitigate significant impacts. That's why they said it was a substantive and significant issue. Then they went on to speak about other matters, but they never said what the impact was that they were seeking to mitigate. And there is no environmental mitigation when you're talking about putting up financial assurance unless you make a real attenuated argument. And then you could take any economic argument and attenuate it all the way till you eventually touch the environment. So I note that there was no statement about that, nor can there be, because this is not a seeker issue, Your Honor. And let me be very, very clear on behalf of the applicant. We take safety extraordinarily seriously. We have a record in this community. We are a member of this community. We have extraordinary safety procedures, and we are proud of our record. In addition, there is a lengthy history in this state of this very type of operation. We referenced the 1988 GEIS, we referenced the 1992 FGEIS, or the program for this, that specifically mentioned the storage of liquid propane gas in salt caverns. And so with regard to the sort of context in which this is being discussed, I think it's important to understand that even though what these arguments are addressing are legally inaccurate and insufficient, we as the applicant take the underlying matter of safety very, very seriously, and we work with the department, and the department regulates this very, very carefully. So I don't want any of my arguments to be misconstrued as me saying that this is not a matter that doesn't deserve attention, but it has already been given the attention in the public safety and other issues. What we are talking about with regard to this issue is solely, as framed by each of the individuals you just heard, an economic issue. They have made it very clear it's an economic issue. They're concerned about the applicant not having sufficient funds to deal with the issue. That is classically outside the scope of seeker, and therefore cannot even be considered in seeker, let alone adjudicated.
Well, there's some consideration of economics. I mean, again, at the balancing at the end of the day, assuming they're unmitigated impacts, then the commissioner would have to balance those against the socio-economic benefits of the project. So there's some consideration of economics. And I presumably, the company has got some insurance to cover its liabilities in the event something does go wrong and there's lawsuits. I guess the question is the petitioners are asking us to look into that, and how far can we look into that to see whether you're adequately capitalized in the event that something goes wrong and all the other safety precautions unfortunately fail and somebody gets injured.
Your Honor, if I could please address your point about the balancing. If the balancing that the commissioner has to do, which you correctly note is social, economic, and environmental, if that economic word in there carried forward, there would be no case law that economics are not proper for seeker.
Well, no, I think doesn't our case law, our authority says that we don't adjudicate economic issues because those are beyond seeker, but they're proposing it's a legal issue. In other words, they're not. I don't think they're seeking to offer any proof on this or have a hearing on it. They're simply raising the question of should the department look at whether you're adequately capitalized in the event of a catastrophe, and is there some authority for us to look into that or maybe require some identification or something along those lines?
I understand, Your Honor, but
So we're not talking about adjudicating a fact issue, which I think our authorities say we don't do generally under secret, but simply the legal question of what do we look at when we're looking at in the economic balance.
Judge, I can only go with what they're saying in their petition. They're saying our DEIS is insufficient. What does that mean? I mean, that means they want to adjudicate it. They call it a legal issue, but then they're saying the DEIS is insufficient. And my point is simply, you can't point to an economic issue to say that a DEIS is insufficient. I want to now get to the balancing. Certainly the commissioner balances economic considerations, and there's no doubt about that. And we've got
And
some.
that's why the EIS has some reference to it. I mean, now whether we adjudicate economic issues, again, I mean, that's a separate question, but to the extent the EIS provides some information about the socioeconomic, background, so that if we end up having to do the balancing, we've got some information which to base it on. An argument that it's insufficient as a matter of law can be addressed, is it insufficient matter of law or not, right? And my initial question is, do we have the authority to look at this?
You don't. The department does not, and that's what I was going to get to that next. And I'm going to give you reasons why. But, Your Honor, we have to. I would like to refocus on why we're here. We're talking about an issues conference.
Yeah.
They want to have this relate to an issues conference.
Right.
It's inappropriate for an issues conference. As I've said for the past 2 days, there are other buckets, response to comments, where we can take this issue, we can respond to comments.
Well, the issues conference, in addition to determining whether or not there's tribal issues of fact, is also to resolve legal issues.
Yes.
And they're saying that their argument is it's a legal issue.
But that's correct, but they're saying it's a legal issue that should relate to the issues conference. I'm okay with this going into the seeker record.
Yeah.
So I want to now, I think it's a good segue into the second part of the argument, Your Honor, with regard to the regulatory, and does the department even have authority to do this, regardless of whether it's balancing, regardless of where we are in the process. The communities said, when you asked what's the regulatory standard, they didn't provide one, and I'm going to get to what Amici said about that. They didn't have any to offer, okay? And the record will speak for itself as to whether they spoke about a substantive and significant issue, but you asked, is there a regulatory standard? They did not provide one. In terms of financial surety and those requirements, Your Honor, through his questioning, and I will only say that Your Honor's questions, I will just translate them into answers, that there is no authority for this. You are absolutely correct that there's no provision even in the ECL for the clause that's in there. The reason it's in there is precisely the reason Your Honor put in his question, which is when you get when you have a permit and the department's issuing it, there's this sort of contract. Not that the applicant has a lot of leverage in this, but they put the condition in there because if the department
That's just an adhesion contract, right?
I would never suggest that of my good friends at the Department of Environmental Conservation. But it's there because in case there's a lawsuit over something, the department wants protection because it issued the permit. So they're sort of participating in the process. And, well, I may have my own views of whether they have the legal authority even to force that. It's a non-issue because we agreed to it. We agreed to it. We're not here to contest that provision. We agreed to it, and we stand by our agreement, and we will honor that agreement. That is much different from someone coming into something we didn't have to do but we committed to doing, that there's no legislative authority for to have happen, and then to say, in addition, we think you're legally insufficient because you should do more and you should protect us. As Your Honor well knows, even in areas where the department has some pretty clear authority, I'll give you pesticides, You can only assess fees against an applicant where there's specific legislative authority to assess the fee. The department has tried at other times to assess fees, etc., and has been struck down by the courts when there's no legislative authority. So I appreciate the fact that amici want to take some time to look for it. They have that right to do so as part of the briefing. We don't see it. We don't understand it to be there. And that really is the key point of the second part.
Does the department look at the fitness of a applicant, though, and at least as part of their financial fitness?
Your Honor, the answer to your question is fitness is an issue. There's actually a rock on that.
Right.
And however, in order to have an applicant be subject to the
ROC is an ROC.
record of compliance, yeah, I'm sorry. Those do exist, but there are certain criteria that have to be met before the department can even require an applicant to go through that process. Those are not met here. And those are really sort of fitness in terms of their track record, in terms of violations, et cetera. That's what that points to. So the answer to that question is, Your Honor, yes, but it wouldn't be relevant here. With regard to the statement was made that we are somehow unique, and that therefore we should, that's another reason to create a law, I guess is what is being said here. We are not unique. There are a number of facilities throughout this state, power plants, I can go on and on and on, that are members of the community that if you were to create a scenario, and I'm not going to get into the risk assessment that we had before, but if you create scenarios that we don't think are realistic, but even assuming they were, it's not unique. There are many other facilities, and the key point is it's for the legislature to decide which situation requires the extraordinary measure of saying to an applicant in New York State or anywhere that you have to agree before you get the permit, that you have to agree to indemnify everybody all around you. I have never heard of it, and it would, in my experience, it would be incredibly unprecedented in this state. But the point, the underscored point here, Your Honor, is there's no authority for it. And so, you know, I don't know why we're going to brief something for which there's no authority. I do understand there's an opportunity given to see if people can find authority, and the applicant understands that part of the process. So, Your Honor, I also want to note, just for completeness, that the wells are bonded. So, in terms of my fellow members of the community of New York State, I want them to know that there are protections that are there. The wells are bonded, so there is that measure. There are the safety measures we take at the facility. There's the department's oversight, et cetera. There are permit conditions.
And they're bonded for what? They're bonded for what? Closure, or what's the bond for?
Plug it, yeah.
I'm sorry?
Plugging and abandonment.
Plugging and abandonment.
Right, but those-
That would come into play if something happened and you had to shut down the facility. There's money there to make sure it gets done. Is that what we're talking
Yeah,
about?
and that relates to safety and sort of the same issues, which is when you have that bond, you have that requirement that motivates the permit holder to do things right, and if they don't, there's a protection there, and the community does benefit from that as well. It's slightly, it's not the issue we're talking about here today, but I just wanted to put that on the record, that this isn't something that's not thought out. It's something that is thought. So, Your Honor, in conclusion, I started with and ended with the two prongs. I talked about seeker, and that in terms of it's not within the zone of interest of seeker to talk about an insufficient EIS, what should be in an EIS, what should be discussed in an EIS. And we've got the Sunco case in it. We've got the St. Lawrence 2001 decision talking about economics beyond the scope of seeker. You and I certainly discussed the balancing of the commissioner. I won't get into that more. And on the regulatory side, it is very, very clear that there is no authority for what is being requested here, sureties, the like. And if that authority is to come, it would have to come, it couldn't come from the commissioner, Respectfully, I don't think it could come from the administrative law judge or even from a court. I think it has to come from the legislature if that requirement's going to be imposed. So again, thank you for the opportunity to present on this issue.
Thank you.
Hi.
Haven't heard from you for a while.
There we go. Okay. So briefly, I want to confirm the department staff's position that there's no regulation or statute that would allow us to require permittees for an underground gas storage facility to provide insurance or indemnity to even close municipalities, let alone those that are 20 or 30 miles away. None whatsoever that we are aware of, no cases that we are aware of at all.
Do we look at the financial ability of the applicant, not only to do what they're required to do with the permit, but
We don't
potentially-
examine it per se, although, as Mr. Alessi said, they do provide bonds under statute regarding the wells. And those are bonds for us, not for the municipalities, if we would have to plug and abandon the wells. And I will also set out that that's under statute, and the statute even regulates exactly how much those bonds can be for. So the legislature's kind of carved out, that they are controlling the purse strings here.
Part of permit review, though, the department doesn't look at whether the applicant is sufficiently capitalized or whatever to fulfill its obligations on the permit.
No. I'd also like to just clarify, because I don't want anybody to be confused regarding the draft permit conditions, attachment 1, permit condition 9. It was not the department's intent in drafting it to indemnify or to seek indemnification from the applicant for any party but the department, the state. I should correct that, the state. It was not the intention to seek indemnification for municipalities. Thank you.
Thank you. So the Seneca Lake Communities, we have 4 minutes in rebuttal.
Thank you, Your Honor. I'll just try and make 3 quick points in rebuttal. The first is we've done as quick a review as we can over here at the table, and would cite merely to the fact that the department does, under Article 23, require bonding of wells, as has apparently been done in this case. My understanding is that that's done by regulation, and 6 NYCRR 552.2, but I may be incorrect about that. In any event, I think the main point that I'd like to make on this is that if, in fact, the department does not have the authority to impose a bond or to otherwise require indemnification for parties beyond the state, then what you have here is an unmitigated significant adverse environmental impact under SECRA that in itself may mandate denial of the permit if it can't be mitigated through some kind of financial surety.
Has it ever been recognized in any case law or?
Not that I'm currently familiar with, although I don't know that it needs to be recognized in case law. I think that if you've got a situation, that takes me to my second point, this is not about economics. This is not an economic argument. It's not an attenuated environmental impact that we're talking about. It's a direct environmental impact. And if, as testified to by Mr. Kuprowitz and the representatives of the Seneca Lake communities, there is an inability to address the immediate or long-term environmental impacts of a catastrophic failure or a slow long-term leaching of salt into the lake, that's an environmental impact, and it relates to water quality and drinking water quality and public safety, and those are environmental impacts that are within the purview of SECRA. And if those can't be mitigated because the applicant does not have the financial wherewithal to adequately address those short and long-term impacts, it's an unmitigated impact.
But isn't that really, doesn't tort law take care of it? I mean, if there is something that happens and the applicant ends up being responsible, and the municipality ends up incurring costs as a result, will they just use, normally they have to go, they have to sue sue them in court to get the recompense, right? And is it up to the applicant to have adequate insurance essentially to cover that if that happens? How's that an environmental impact? Is that really an economic?
No, Your Honor, it's not, because our position is that there would be at least a year, and it's set forth in the affidavits that we submitted from the city manager and the manager of the Waterloo treatment facility. There would be at least a year in order to design and implement water treatment facilities that would be able to adequately treat this water, during which time Matt Horn, the city manager for the city of Geneva, says they are not aware of any avenue to provide drinking water to their residents. That's an environmental impact.
Right, but what you're seeking indemnification for would be the economic impacts if something like that occurs.
To implement the remediation of what is an environmental impact, that's correct.
Right.
So it's fundamentally, at its core, what we're talking about is, are you going to have unmitigated significant adverse environmental impacts within the sense of SECRA? If you're permitting an activity for which there is no ability to provide adequate financial assurances.
Thank you.
Thanks.
Thank you, Your Honor. I am not certain what I said earlier, but if I misspoke or that was interpreted as a pure economic impact, certainly that's not our intent. That's not what the petition says. And even though there may be monetary issues here, that doesn't make it an economic impact. What we said in the petition was that this issue goes to human health and safety and impacts upon agricultural uses, including the health and safety of crops and animals, which may be subject to exposure from fire, explosion, or the slow escape of stored gas. I'd also make just a minor point, and that is we've segregated this issue out for purposes of this conference, but in our petition, we tied together risk assessment and indemnification. We don't think that they are particularly segregable in terms of looking at this issue. And because of that, I think it highlights that this is, in fact, an environmental impact, that this is socioeconomic, and that it's not necessarily something that we look at just in terms of the indemnification. In terms of the uniqueness, again, I would have to defer to the court reporter, but it's the uniqueness of the impact of this project upon, particularly from our perspective, the Finger Lakes wine region, that in the event of a catastrophic event, it's not going to be just a question of money, but certainly the environmental impacts will be vast and far-reaching. So
Well, but that we talked about when we talked about the environmental impacts, the potential impacts on public safety, but the specific challenge to the indemnification clause seemed to be that you were seeking indemnification not only, the department, but for other parties that might be injured. So that's why I kind of try to focus it down on our authorities to do that.
I certainly understand that focus, but I think even in the department, what the department's looking for is, quote, anything the state might be responsible for as a consequence of the applicant's actions. I would also submit that the state, the department, speaks to we, the people of the state, and the injury that is incurred here. We're not asking for an indemnification insurance policy for the Finger Lakes Wine Region Business Council, although certainly if the applicant would like to provide that, we'll take it. But we are looking that if the applicant is in a position where there are injuries to the people of the state, that they are in fact financially capable of doing so. And we would submit that although this might be a somewhat novel concept in the context of this hearing, I don't see anything in the regulations or the statutes that prohibit an inquiry of this nature. And that's why we do believe that it is an appropriate legal issue and a policy issue for us to attempt to address with you in this context and in the adjudicatory hearing, that there should be a requirement. The fact that there is a requirement for bonding on the wells, the fact that there is an opportunity in circumstances to look at the financial wherewithal, we think that this circumstance also justifies that type of a review.
Thank you.
Thank you.
Right, so that concludes the indemnification clause issue. That moves us along to public need and benefit. Does anybody wish to take a brief recess, or should we just continue? Sorry you had to be last, but somebody had to be last. Are you reserving any rebuttal time?
With your leave, I would reserve for rebuttal anything I don't use in my direct.
All right.
Thank you, Your Honor, for the opportunity to address you here today in this, which is to us an extremely important proceeding. My client, the National Propane Gas Association, is a national advocacy group for the propane industry. We represent, and our members include, producers of propane, transporters of propane, manufacturers of propane equipment, and most importantly, propane retailers, of which there are about 2,500 members who deliver propane to consumers, principally residential, agricultural, and commercial customers. We have those members in every state, and we frankly believe that at least in the lower 48, every county, perhaps with the exception of Manhattan, our members exist. Our members deliver propane to 6 million households in the United States, 250,000 of which are here in New York. The propane in the residential sector is principally for space heating, for water heating, for cooking, and to lesser extents, pool heating, fireplaces, etc. There's been a lot of discussion here in the last 2 days about agriculture. Propane is exceedingly important in agriculture. It runs irrigation pumps. It runs crop drying operations. And as we found out last year, is exceedingly important in poultry and livestock facilities. In fact, I don't know for a fact, but I would expect that the members of the Seneca Lakes or Finger Lakes Wine Business Coalition are large users of propane in their operations. Most people don't realize it. Propane is also used in vehicles, fire vehicles, principally in school buses. A third of the school buses made in the U.S. this year will run on propane. In fact, there are more propane vehicles on the road in both the United States and the world than either electric or natural gas. I want to shift the perspective a little bit here today from what we've been talking about the last 2 days. Some of you may have noticed that it's a little chilly outside. The business that we are in is warmth. And this project and the people, our members who will put propane into this storage facility if it's built, are delivering warmth to their consumers, an essential human need. And we would urge you to consider this project in that context. Should this project not go forward, and we view it as an essential part of the national infrastructure, and I'll discuss that in a minute, the alternatives are pretty clear. People can heat their homes with electricity, first electric resistance, which is hideously inefficient, or heat pumps. But even so, 50% of electricity in the United States is generated by coal. And so propane is a much more environmentally benign way to heat a home than electricity. Natural gas also is very similar to propane. We call propane portable natural gas. But people who use propane to heat their homes in all likelihood do not have natural gas infrastructure near them, which is why they use propane. In this area and to the northeast of here, fuel oil is very important, but fuel oil is largely imported at this point, or significantly imported, and is very bad for the environment in terms of emissions. Also terrible for homeowners having to clean burners and that sort of thing. And
Can I ask you a question real quick?
sure.
I'm going to ask you the same question I've been asking all the amicus petitioners, which is that amicus petitioners generally are not in the proceeding in order to provide information that's not otherwise already in the documents. They're simply to provide legal argument. The parties that want to provide information generally seek full party status.
Correct.
It seems to me from your petition that you're proposing to provide information about a variety of different subjects, reliability of propane services, reduction of greenhouse gases, need for additional storage. That sounds to me like you're wanting to put in additional information that's not already in the application materials.
I think, Your Honor, that much of this is in the application materials, and to the extent that it isn't, it would be a matter of public record of which you could take judicial notice and on which we could make policy arguments.
Take judicial notice on things such as reliability of propane service. That doesn't sound to me like something I can take judicial notice of. I can take judicial notice of notorious facts. What time the sun rises and sets. But
What are you meaning about reliability, Your Honor?
Well, that was your petition. You're proposing to provide information concerning the reliability of propane services in New York and the surrounding states and how this project impacts that.
I think the application addresses that, Your Honor.
Okay. So your role then would be, if I allow party status for you, that you will be submitting briefs that will basically, based on the information that's in the application.
And in the public record, US DOE information, et cetera.
All right, so you're not proposing to provide me with any new information that's not already in the...
No, Your Honor, except, I mean, should you request that, we would gladly do it. Let me talk briefly about infrastructure, because this is an infrastructure project. Propane production is at record levels of the last several years, but we are in the process of replumbing both propane infrastructure and natural gas infrastructure. And this project is a critical part of that. We have seen one of the two TEPCO lines that serve this area and are frankly the backbone of the Northeast and Mid-Atlantic and Midwest propane markets be reversed. And so now the ability to get propane and other fuels to this area has been constricted, so storage is much more important. Storage located here that can support New York, New England, and actually even parts of the Middle West. Last year, in the winter of 2013 and 14, we had the worst winter the propane industry has ever seen. The Midwest was very hard hit, both in homeowners and in farms, agriculture. New England also was very tense, and frankly, the only thing that prevented New England from having trouble was they imported propane for the first time in 6 years. For those of us who worked on those issues, we said all along last winter, if Finger Lakes were in operation, this would be an entirely different situation. Last, obviously, your job and the job of state government and also federal government is to protect consumers from environmental risks. We endorse that. We believe that facilities should be built to the highest standards, that government should oversee and regulate them. But we also believe the role of both federal and state government is to provide for the needs of consumers, and energy such as propane, natural gas, etc., is an essential human need. Almost without exception, either state or federal government or both are involved in processes for permitting the infrastructure. And it's our view, certainly, that those essential human needs have to be considered when permitting facilities such as these, as well as the environmental impacts. Let me stop there. I'm glad to answer any other questions you might have, Your Honor, and we appreciate the opportunity to be heard.
Sure. Thank you.
Thank you.
1 minute, 30 seconds remaining, so.
Good afternoon, Your Honor.
Good afternoon.
I'd like to reserve 2 minutes for rebuttal.
All right, so,
I represent the New York State Propane Gas Association, as well as the Propane Gas Association of New England. And I'd like to reiterate what Mr. Petrash said, and we fully support the project as well. The New York Propane Gas Association consists of 337 organizations, and they are involved in all facets of the propane industry, including retail. So the Propane Gas Association of New England has 675 members in various states in New England, and as well, they're also involved in all aspects of the propane industry. So we do have a unique perspective here, along with Mr. Petrash, and I think that this is a perspective that the court, that Your Honor and the Commissioner would find particularly helpful in viewing this project as a whole. We're seeking amicus status to not provide new information. We're going to rely on the information that the petitioner or the applicant has already supplied. However, we also want to focus on the importance of Article 23, Section 301 of the ECL, the stated purpose and position of this state with respect to minimizing waste and encouraging the efficient storage of gas. And there's two key areas that we'd like to address with respect to that. There really is the environmental interest of the project and the consumer benefit of the project. Let's talk about the consumer benefit first. We've heard a lot of discussions today, especially from the communities, about the fact that there's no local benefit, or there's no benefit here to people in the greater southern tier. And that's simply not true. Propane is a supply market. It is not an export market. And the fact that there's more supply means the prices are going to be less. So there is a huge benefit for local people, especially considering that the majority of users of propane happen to be living in rural communities, such as the town of Reading and other towns locally. So these costs, in past, current storage capacity is insufficient. I think everybody realizes that. And in the past, retailers have had to import propane from faraway places, such as other countries. And this increases the cost of transportation significantly. And guess who pays for the cost? The consumer does. So this project has an immense impact locally. And we're going to address that, and whether it's in connection with the alternatives argument or in the benefit argument, it's an important part of the project that the Commissioner and Your Honor needs to consider. I also want to just discuss the delivery efficiency of the project as a whole. And traditionally, having to transport propane using diesel really defeats the point, to some extent, of the efficiency of propane as a whole, because you're using diesel fuel to transport the propane to consumers and ultimately not gaining the best benefit and increasing more waste, which is inconsistent with Section 301. So we'd like to address...
Trains use diesel, don't they?
Trains use diesel to some extent, but they also use electricity.
They use electricity up here.
But they're much more efficient than... No, they use diesel up here, but they're much more efficient than putting it on the back of a truck and driving it. So that being said, it's a much more cleaner fuels. Propane's a much more cleaner fuel source, and I think everybody here agrees with that. But importantly, what I'd like to just say is that it's going to decrease cost volatility to the consumer, and that's really a huge benefit here. And getting to the environmental concerns, which I'll touch on kind of briefly, greater access to the propane, which this project will encourage will actually de-incentivize people to use alternative methods, which is what Mr. Petras stated. And some of those methods are more dangerous. They're certainly less efficient. And such as electricity. You know, if you don't have access to cheap propane, then you're more likely to heat your home using your oven or with an electric space heater or using some sort of a wood-burning furnace or something, or even oil. And I'd also like to wrap up with the security of the supply is also a very important consideration here. And having the ability to not have to rely on foreign nations and foreign areas for consumer consumption of propane there's a huge benefit to that. If by storing it here, having more propane here, and having the consumer have access to that propane actually encourages New York State being an independent operation for propane in a storage facility for
Is the
propane.
propane going to be stored here, or solely going to be generated here in New York?
No propane is generated in New York. But the important part is that it's stored here and it's available for use here.
Right, but if what you're saying is the benefit of not having to rely on foreign countries, where's the propane coming from?
It's a great question. It's coming from Texas. It's coming from the Midwest. It does come
from Canada?
It does come from Canada as
Well,
well.
that's a foreign country.
It is. But important to point out is,
Having a company in the Middle East, is
Right.
that-
I didn't want to go there, Your Honor. I didn't want to go there, Your Honor. No. What I mean is, last year when there was a fuel shortage, we had to actually import fuel from propane from England. They had to bring tankers over. So that's really what I'm referring to. I'm not necessarily referring to Canada as a whole. I'm just referring to the necessity to go to a foreign nation that we haven't historically had to go to in the last few years because there's a shortage of propane.
But having a storage facility here, does that, oh, yes, okay, I got it, never mind.
And I'd like to just wrap up by saying that I do think we have a unique voice here, and I do think we have a unique perspective, and we do support the project. And again, I'll defer to Mr. Petrash's analysis of the propane industry as a whole. Thank you.
Thank you. So I have 9 minutes for the United Steelworkers.
9?
I'm sorry, 10.
Thank you. Thank you, Your Honor. USW has put in a petition, and as agreed, I will stick to their petition with regard to the basis for their amicus status in support of the application. As indicated at page 2 of their petition, they speak to the public benefits of the project, boosting the economy of the region, helps to lower propane costs for consumers and meet the energy needs of the state of New York, helps retain jobs.
Are they proposing to provide the record with information that's not already in it?
Pardon me?
Are they proposing to provide information for the record that isn't already in the record?
Absolutely not, Your Honor, and that's what I was going to get to. I was going to give you citation by citation of where it is in the record as to every single thing I will mention here. And the report, fortunately, the amicus starts it with their footnotes, and I will continue it because one document. They reference the applicant here, and so I'll have that document. Your Honor, public need is very, very important in this matter. It is very important because it's part of the basis upon which the commissioner will do his balancing. And it is not an insignificant matter, and it is important because out of all the issues we've discussed here today, this affects the most people in a positive way. Their energy cost and reliability of people is about the most fundamental thing you can have. The power to put your lights on in your home, to feel secure in your home, that your alarm system, if you have one, to be able to make sure when you're sick or infirm you have appropriate heating. It goes on and on and on. It is one of the most fundamental aspects of our lives. substitute. Most of us perhaps do not use propane in this room, but there are an extraordinary number of people in this community who do in this area of the state. But just think if you didn't have electricity. Think if you didn't have the natural gas in your home to live. It's an extraordinarily important aspect of daily lives. And the number of people it will benefit in this county is extraordinary because of the number of people who depend upon propane. And that is what the USW goes to in talking about in their petition in terms of the benefits that this project will have. With regard to their interest, Your Honor, they speak to the fact that the USW has an extraordinary track record in support of clean energy. They consider propane to be a clean energy source. They work on projects for clean energy projects daily in their lives. They have an extraordinary interest in making sure that they get to express their own views of what should be the balance of energy and clean energy. So their environmental interest and their interest in general is established. With regard to the needs that they speak about they talk about the energy needs of the state of New York and the entire Northeast. That's on page 2. And with regard to that particular issue, you can turn to the DSEIS in this proceeding that the USW will rely upon. I'm going to do it from memory. I think it's pages 12 and 13 that talk about these very issues, talk about the volatility that occurs and has occurred. You've heard from other amici about this volatility. Volatility is not some academic ethereal concept. It affects how much people have to pay for a fundamental need. They don't get to use propane as a discretionary spending item in their budget. They must have it. And what happened to people, as we put in the DSEIS, their cost went up in an extraordinary amount, and it was sudden and it was unplanned. Those are not the types of public situations anybody should want to have. Who are these people that are affected? These are seniors. These are some of the most vulnerable people when it comes to these particular types of issues. So the public need is very, very compelling. With regard to the support for this project, USW is proud to have been participating in the support for this project. Over 1,000 signatures, residents, over 300 businesses, some of which are wineries, who have supported this particular project. So they work in the community, they live in the community, they are members, they support the project, and they are out there advancing their support. They're,
In the public comments somewhere, this petition?
oh yes,
Okay.
yeah, it's in there. And with regard,
Oh, last night at 1 o'clock.
no, I didn't. No, I didn't go read through them last night at 1 o'clock. In terms of the further aspects of the public benefit, Your Honor, well, we have focused on the region, and I want to say something about the region. I want to talk about the public support. The Schuyler County Legislature and the USW has participated in getting this support, has the support of the Schuyler County Legislature. And there's a resolution that has been passed in support of it. So while there are 2 legislators here today, a member of that legislature, I'd like to make sure, and it's a public record, the support that the Schuyler County Legislature has, and the USW is proud to have participated in the establishment of that support. And I would also, Your Honor, in support of the petition, in terms of the how it benefits the public and where that's reflected in the Schuyler County 2014 County Comprehensive Plan, and this goes.
Does the petition of the United Steelworkers talk about the Schuyler County legislation?
Your Honor, the petition does not. However, we have heard discussion for 2.
Yeah, but I think we're limiting this discussion to what was raised by the United Steelworkers in their petition.
Your Honor, we talked about, and that's where I was going to go. On page 2 of the petition, it talks about the Crestwood project will help to boost the economy of the region. And that's where I was going with the County Comprehensive Plan. It talks about, page 68, the economic climate of the town of Reading, the host community.
Do they cite the county plan?
They do not cite the county plan.
I think for purposes of this discussion that we'll allow them to brief what they think
Okay.
is appropriate when on that.
Your Honor, with regard to so am I not able then to reference the environmental impact statement that everybody else has referenced if it's not in their petition?
If they make arguments about matters that appear in the environmental impact statement, that's fine. I don't want to give you the applicant rebuttal time on issues that we've discussed already.
Well, Your Honor, I'm standing in the shoes of the USW,
Okay.
and I think I'm entitled on their behalf to speak to the issues on page 4 where they talk about seeker in Article 8.
Okay.
And that's, as I said to you, I would provide the citation to each part of this petition so that you can be assured that I'm going to do that. So it's on page 4, thank you. So with regard to seeker, as they cite to in their petition, the issue here is, with regard to the balancing that Your Honor talked about, that these economic considerations are very important. And when you have industry like this industry, and the town of Reading speaks about that it is going to have a positive impact, we talk about that in the EIS. The EIS has that. And when you see at the bottom, source Crestwood Midstream, they're referring to the Camoin report. And in the Camoin report, and I want to underscore this, the results of the study indicate that the net economic impact of the project is expected to be positive. Overall, the project will have a one-time economic impact to Schuyler County of 58 jobs of USW people included, $2.3 million in earnings, and $5.6 million in economic output. Additionally, it will generate an annual economic impact of 17 jobs, $684,000 in earnings, and $507,000 in indirect economic output in the county. The net fiscal impact of the project, i.e. municipal revenues, less expenditures related to the project, will be $613,000 annually. Those are all extraordinarily significant numbers in a positive way. So when we've been talking about the balancing that the commissioner needs to do, he balances both sides of the economic coin. And we want to, on behalf of USW, make sure that the record is very robust about the virtually uncontroverted positive economic impacts, both individual and net benefits, because what happens is the report that's referenced here in their petition, the Camoin report, Camoin was intellectually honest. They said, there's some costs that are going to go to the community from response and other issues, but there's benefits, and the net benefit is still going to be $613,000 annually. So in sum, Your Honor, USW has a very deep member of the community. They have participated before the legislatures. They participate in clean energy jobs, and their interest is to show the economic benefits, but also the clean energy because of the low carbon content of the propane fuel. Thank you.
Thank you.
Your Honor, I have just some short comments. One has to do with the place of discussion of public need. And contrary to NRDC statement, it is, as you have sort of indicated, it's there to balance adverse environmental impacts and findings. And I know you're familiar with Judge Burmaster, and he has he has an excellent discussion of it on page 35 of the Seneca Meadows decision 2012. So I won't say anything more about that.
Sorry,
Page 35 of the Seneca Meadows decision 2012.
It's here report.
Yeah, yes.
Yeah, I don't think the commission's decision was 35 pages long.
Okay.
Judge Burmaster tends to write quite a bit.
Okay. Okay. Well, this is a very cogent discussion, and additionally, and not to overload your reading, but there is a interesting historic discussion of underground storage in the bill jacket to the underground storage law. And just to save everybody's eyes, we will append a copy, the relevant pages from the bill jacket, rather than having to have people go find it. And also,
What is that?
the bill jacket to the underground storage law from 1962.
The entire bill jacket?
We're not, you don't need to read the entire bill jacket. There's just a discussion of the underground storage law and the need to create underground storage in New York, and because of shortages of propane. And I'm doing that, I have to say, from memory, because I researched that in connection with something else, but I remember there was a discussion in the bill jacket on that. So my memory may be wrong, but I think it's right. And finally, the other thing I want to mention is that there's a decision that there's a finding statement that the department issued in town of Hounsfield, where there's a town of Hounsfield.
Hounsfield?
Yeah, it's a wind project up on Lake Ontario on Galoo Island, and there's a good analysis of cumulative and public need and how that is handled in a finding statement. And that case was actually litigated, Town of Henderson versus DEC, and the department was upheld through the appellate division. But
Am I going to be able to find that?
Well,
statement?
it's on our it's on the DEC's website, but we'll append it to our brief so you don't have to find it, and we'll just append the relevant sections from it so you don't have to read the whole thing. So that's all I have to say. Thank you.
Thank you. So there's rebuttal time if you wish to use it. You've got 1 minute, 30 seconds.
Your Honor, with your leave, I don't intend to rebut, but I would like to respond to a question you asked my colleague about Canadian imports and the like. Yes, it is the case that the United States imports propane from Canada at the moment. Those this year will be less than last year as a result of the reversal of the Cochin pipeline in the Midwest. But nevertheless, because of the increase in shale gas production, most of that is wet gas that produces propane. Propane supplies have been increasing dramatically, and you can see this all on the U.S. DOE EIA website. The result is U.S. production of propane is more than sufficient to meet U.S. Propane consumption needs, both residential, petrochemical, agricultural, et cetera. And so that is a real benefit of shale production. Thank you.
All right. Thank you. So that concludes the oral argument portion of the issues conference. So let me go off the record. So I guess what remains to be done now is to discuss briefing, as my impression is everybody wants to do that. Does anybody want to take a break quickly before we do that, or should we just keep going? All right. Do we want to try to set a schedule? Do the parties want to try to settle a schedule without my involvement?
The timing on the transcript.
The timing on the transcript.
Your Honor, I just have, I did want to make a request that we have a transcript before we try to do this.
Right. 2 weeks, approximately.
Can we get it electronically, Your Honor?
I've asked for it, yeah.
I'll throw out 30 days from the time we get the transcripts.
Okay. For opening, I assume the parties
How
are
do you
going to
want to do
have
it?
opening briefing and then a responsive briefing after that.
Well, Your Honor, they have potential parties have the burden of persuasion. We would like to follow the traditional course of, they put in their brief, we get an opportunity to respond to it.
Your Honor, I think that under the circumstances, it would be more appropriate to follow your suggestion. The department decided not to submit any materials whatsoever, to which we, in response to our And so and instead presented some fairly detailed, complex arguments, bringing in things that were not before us. I don't think it's appropriate for us to have to respond without fully understanding that. I guess the transcript, I guess, was a little...
Right, you'd be responding to what's in the transcript.
Right. I still think that it would be appropriate to be doing the cost briefing just because it's not as if we still have the burden of persuasion, they'll still have an opportunity to respond to us, but we would have to be in a position to respond to them as well.
I guess the question is, I mean, what would applicant be doing in initial brief? Is there something that...
We could respond to the petition for part. I mean, we do have the petition for part status. We do have what was stated on the record. So, I mean, we don't have a problem.
Your Honor, your notice, which was one of the other things I read late at night, was your notice basically put in to deal with situations in terms of whatever we put in was without prejudice to us putting in written responses, et cetera, in the ordinary course. I'm not sure I understand Gas-Free's proposal. I may agree with it, but I didn't hear what it was. I don't know what they're proposing, I guess.
Well, you correct me if I'm wrong, but ordinarily in these proceedings, and I've never really quite fully understood why we do it, but traditionally we've had everybody's file a written opening, closing brief, and then everybody responds. That's the way we've traditionally done it. I presume that's what you're asking for.
Yes, either that.
I mean, conceivably they might choose not to file an opening brief, even though.
Right, but alternatively, if we're going to do it sequentially, then we certainly would want an opportunity to reply, as it would be normally the case in the
Right.
schedule.
Yes. Right. So okay. So I see. So in other words, you want to have an opportunity to reply to their response to
Correct.
you.
We
Just
will
so
do
you know, normally
simultaneously
we just
if
all
that's
throw
their
it at the
proposal.
same time. Every single party, there's not that important.
Yeah.
It's normal for DEC.
Every proceeding we've ever done is...
I argue against it every time.
Well, we don't necessarily have to do it. I've never understood it because, why would a party file on something that they haven't? I mean, we already have pre-issues conference briefings, so to the extent that, the applicant wants to respond, the staff wants to respond to the petitions, the applicant at least took that opportunity in writing, and the department did it
We ran out
orally
of
at
time.
the issues
Well,
conference.
yeah, we
Yeah.
really ran out of time. It would have been
We're
nice.
okay with simultaneous. Because with simultaneous, there was, right, so it would be,
Which department?
there might still be an application for a reply even with simultaneous, because if
Both sides.
right,
Simultaneous.
when we can, I guess we can deal with that when it comes up. That-
Yeah, I mean,
If we do simultaneous, everybody will file an opening brief, everybody can file a response, and then if
Then
parties wish to have some further reply, then at that point, it would be by leave anyway, you'd have to ask for it. We would,
It does
take
sound
into
a little,
consideration.
it sounds like it might be a better use of everybody's resources to have us file a brief, have them respond, and have us reply, rather than having
No.
all of us write 3 different briefs.
No. I mean, in every proceeding I've ever done, it's always everybody files an initial brief, and everyone files a reply, and then the lead files the reply. And it always takes us off because everybody files a motion for lead to certify and includes their motions. It's like already out there, but nevertheless, it's always initial and then brief. And then part of the reason I think an initial brief from everybody would make sense here is because we did have time limits, and it was necessary to have time limits, but obviously, we did run out of time to actually talk about some of the stuff. So there's some things that were in the petition that we didn't get a chance to respond to, which we could do easily in an initial brief. So,
Right, so your opening brief would be addressing issues raised in the petitions, in the response, and in the issues conference. And then all parties will have an opportunity to respond to that. Okay.
We would also, Your Honor, as you put it in the notice, we put in our brief, we didn't put in all of our arguments. We would want to follow through on your notice and be able to do it as we would. So we did not propose a reply for the applicant. So if that is their proposal, we support the department, go back to the traditional way that Your Honor articulated. Simultaneous initial briefs, simultaneous responses, and then a party's going to have to serve leave and get Your Honor's permission to establish the basis as to why they would want further briefing.
Right, that would be the normal course.
That's fine with us. I'm just trying to save people some time, and if they want to write 2 briefs, that's up to them.
We would have. So we always order, we always, no matter what.
All right. Excellent. So, the initial proposal was the initial round would be 30 days after the transcript is available. And then responses.
The only thing I'll throw in here, Your Honor, I don't mean to be, but if it falls in the middle of a Jewish holiday, can we just extend it a little bit? Could really mess with my life.
Sure. You'll have to tell me though. Because
I don't know the transcript.
I've lost track of them.
I know, you don't keep track, no, I don't know exactly when the transcript will come, but, April will be difficult, the beginning of April.
And we made, there are other religions that have the same issue.
Anybody else, I'm not, trying to throw anybody else off track.
No, of course.
30 in 2 weeks.
30. Let's see if we can get like the general parameters. So 30 days to do the initial brief, and then 2 weeks to do the response. Is that work for you all?
Or do you want more? 2 weeks for the reply? That's fine.
Kind of those things. We get 1,000 pages.
Yeah, I would take more.
30 and
If we
30.
get less than 300 pages.
30 and 30.
Can we set a page?
So you're okay at 30 and 30?
We're gonna read all of them.
Yeah, you're going to get.
Seems like they're 30 and 30.
All right. So then what we'll do is when the transcript is available, I'll look at the calendar and see what 30 day, where that takes us. If it lands in a Jewish holiday, then we'll adjust it, and then we'll look at the 30. Generally we're going to go for 30-30, but it's all going to depend on when we get the transcript, and we'll settle at that point. Does that make sense to everyone? Yes.
I think we just have a brief question, since we are proposing it as amicus status, not as full party status. Would there be any problem with us just responding? I mean, we filed our brief for party status, and I think that if once we get a brief, I assume opposing that, we could respond to it. But, it's an issue of resources for my client, quite frankly. I feel like we would be rewriting the initial brief.
Yeah, certainly. I'm not going to require that you file a brief. Yes.
But we want to be able to respond.
Yeah, absolutely. Yeah.
Your Honor, I don't object to that general proposition, but we can handle this now or we can handle it later. I just want to make sure, because we've been in this situation several times when that request is made and the response ends up being supporting another third party aligned, and we never really get the opportunity
Well,
to
then you
see
make
us.
your motion for them to file a reply.
Okay.
All right? Anything else? No? Okay. So I'm going to try to articulate this on the record. So, while we're going on the record, we just had a brief discussion about the briefing schedule for this matter. And it's basically been agreed that once the transcript is available, which will be in generally about 2 weeks or so, that we will have the initial briefing will occur 30 days thereafter, and then responsive briefing will be 30 days after the opening briefing is filed. Requests for replies will be by leave of the administrative law judge, as is provided for under our regulations. Once the transcript is available, I'll issue an email to the parties establishing the dates of when the various submissions are going to be due. And all of the previous filing rules that we've been following in this proceeding will apply to the brief. So email service will be fine, provided there's a hard copy followed by mail. Is there anything else at this point from anyone? So, hearing none, we're stand adjourned at 1:52.